Welcome to this recording from the Office of the Superintendent of Professional Governance. We appreciate your interest in learning about reserved titles, regulated practice, and reserved practice. This presentation will explain the significance of reserved titles, what regulated and reserved practice means, and where you can find more information about regulated and reserved practice under the Professional Governance Act, or PGA. The information in this presentation is not legal advice. The presentation is intended to provide a general overview of the policy purposes of some key concepts in the Act. You should seek advice from an appropriate professional if you need assistance understanding your obligations under the Act, or what the legal effect of the legislation is. This presentation is an introductory overview on the concept and framework for reserved titles and reserved practice. It will not provide information on specific PGA professions' reserved practices. We will start by discussing reserved titles. Protected titles are a relatively simple idea. They exist in many professions, not just under the PGA. For example, only a person registered with the BC College of Nurses and Midwives is allowed to use the title midwife. Only a registered member of the Chartered Professional Accountants of BC can use the titles Chartered Professional Accountant and Professional Accountant. Protected titles are intended to help the public know who is a registered, qualified practitioner of a profession. The PGA uses the term reserved title to refer to a title set aside for the exclusive use of certain professionals. Regulations under the PGA provide reserved titles for each PGA profession. The slide shows the professions under the PGA, current as of 2025. The right-hand column shows an example of a reserved title for each profession. For simplicity's sake, not every protected title is shown on the slide. Most PGA regulatory bodies have a registration class for technician-level practitioners of the profession, with a corresponding reserved title. For example, a technical agrologist. All PGA regulatory bodies have an in-training class for registrants working toward a full license, with a corresponding protected title. For example, articling agrologist. Many of the PGA regulatory bodies have a limited license class. For example, a limited license agrologist. A limited license gives a person the ability to practice within a specific, narrower scope of the profession. A complete list of reserved titles can be found in the relevant PGA regulations. Be aware that there may be additional titles and regulatory body bylaws that differ slightly from the regulation's reserved titles, or for registration classes that do not have a reserved title under the regulation. PGA regulatory bodies have a legal responsibility to preserve and protect reserved titles in the public interest, and to guard against the unlawful use of reserved titles. It is important to note that using a title similar to a reserved title, or containing words within a reserved title, can potentially be prohibited. This is due in part to a provision in the PGA that has the effect of prohibiting using a title in a way that implies that the person is a registrant, or is associated with the regulatory body, or is authorized to practice in a profession that is subject to a reserved title. This helps prevent people from inventing highly similar titles that could mislead the public into thinking a person is licensed to practice a profession. As a hypothetical example, a person calling themselves a certified forester could potentially be subject to enforcement action even though they did not use the exact reserved title of registered professional forester. All regulatory bodies under the Professional Governance Act have a regulated practice. The PGA defines regulated practice as the carrying on of a profession by a registrant of a regulatory body. But what does that actually mean? For each regulatory body, a regulation under the PGA defines the body of knowledge or list of disciplines that the advice and services of that profession are based upon. In many cases, the regulation further defines the applications, or uses, that the body of knowledge or list of disciplines must relate to. Regulated practice may also include advice or services that are not strictly part of the body of knowledge or list of disciplines that makes up the profession, but that are ancillary to the practice of the profession. Ancillary means advice or services that directly support or enable the practitioner to carry out the practice of their profession, such as bookkeeping or records management. That's because there is a risk that unprofessional or incompetent provision of such advice or services would undermine public confidence in the profession generally. Where a person is carrying out work in the regulated practice but not the reserved practice, registration with the regulatory body is not required. However, a non-registrant would be prohibited from using any reserved titles for the regulated profession. When we say reserved practice, we are referring to what people sometimes call practice rights, or exclusive right to practice, or restricted activities in other contexts. But what is the public policy reason for defining a specific set of professional activities, and making laws that only certain people can perform those activities? The general reason to have a regulated profession or occupation is that there are public and environmental health and safety reasons, or economic reasons, to set specific standards for entry to the profession, and to oversee the practice of the profession. Not all regulated professions have a reserved practice. In some cases, you must be a member of an association or society in order to use specific professional title, but membership does not result in an exclusive right to undertake certain activities. But why should some regulated professions have a reserved practice and not others? In short, reserved practice areas are intended to ensure only qualified people provide certain advice or services that pose a risk to the public or the environment. The requirements to obtain a license to practice a profession help ensure professionals have the education and experience to practice competently, which is especially important in higher risk areas. Once licensed, ongoing oversight by a regulatory body helps ensure professionals remain competent, ethical, and up-to-date on evolving practice standards. Additionally, the complaints and discipline process makes it possible to hold professionals accountable for incompetent or unethical practice. Reserved practice is intended to have the result that qualified, accountable professionals provide advice and services in areas that pose a public or environmental risk. Designing bridges, mapping out areas where timber must not be harvested in order to protect watercourses, assessing harm to animals or plants from a proposed mine. These are all examples of activities requiring a high degree of professional expertise and accountability, and that are in professions reserved practice under the PGA due to the risk they pose. Looking to the text of the PGA regulations for each profession sheds additional light on the public and environmental protection rationale for reserved practice. The regulations contain a definition of protective purposes, which means the safety, health, and welfare of the public, including the protection of the environment and the promotion of health and safety in the workplace. Under the PGA, the reserved practice for each profession is advice and services within the profession's regulated practice where, having regard for the protective purposes, the experience or technical knowledge of a registered professional is required. The reserved practice is always a subset of the regulated practice. It is important to review and understand the PGA and the regulation for each PGA profession. The regulations may contain exceptions to reserved practice, or clarify areas of interaction with other professions' reserved practices. As one example, the agrologist regulation specifies that the practice of agrology does not include a. the provision of advice or services within the reserved practice of a registrant of another regulatory body, or b. a normal farm practice as defined in the Farm Practices Protection, Right to Farm Act by a person on the person's land. Other exceptions to reserved practices may also apply, and may not be obvious through looking at the PGA and its regulations. This recording will not provide detail on all possible exceptions to reserved practice, but to share one example, PGA Section 55 clarifies that existence of a reserved practice does not prohibit a person from practicing a profession, discipline, or other occupation in accordance with this Act, regulations made under this Act, or another enactment. This is intended to ensure the PGA and its regulations do not conflict with or accidentally override an existing right to practice a profession or occupation. Another important clarification relates to indigenous traditional knowledge and cultural practices. The PGA clarifies that reserved practice requirements do not apply to a person exercising the rights of an indigenous people in relation to traditional knowledge, cultural heritage, and so on. A reserved practice does not necessarily require everyone providing advice or services to be a registrant of the relevant regulatory body. People can provide advice or services under the supervision of a registrant who has a right to practice in the reserved practice, with the supervising professional accepting accountability for the person's work. Not every registration class for each regulatory body has reserved practice rights. As an example, an engineer in training working in the reserved practice of professional engineering must be supervised by a professional engineer, or if applicable, a professional licensee engineering. Just because a person has a reserved title does not mean they are authorized to provide advice and services in the reserved practice. Technician class registrants may have reserved practice rights, though likely not for the full scope of the reserved practice. As an example, a registered forest technician can work within a specified subset of the reserved practice of professional forestry. You would need to consult the bylaws for Forest Professionals BC to understand what a registered forest technician can sign off on independently. The regulatory bodies have authority to interpret and apply the PGA, its regulations, and the bylaws the regulatory bodies make in accordance with the Act and regulations. Regulatory bodies provide information, advice and guidance on where the boundaries of their reserved practice are, and can take enforcement action for infringement of their reserved practice. To fully understand each profession's regulated and reserved practice requires considering the PGA itself, its regulations, the bylaws of the regulatory bodies, and policies set by the regulatory bodies. As background, a regulation is a legal instrument made under the authority provided in a bill that was passed by the Legislative Assembly. Regulations are often used to set out more specific detail, or to establish rules and requirements for things that may need to be updated over time, such as fee and fine amounts. Regulations do not need to be reviewed and approved by the Legislative Assembly. Instead, the Lieutenant Governor in Council, informally referred to as Cabinet, may exercise regulation-making powers if the Act provides the power. Ministers may also be granted regulation-making power by an Act. The PGA provides authority for the Lieutenant Governor in Council to make regulations for professions under the Act, including establishing reserved titles and reserved practices. Regulations prescribe the regulated practice of each profession, and establish a reserved practice if applicable. If you would like to view the PGA and its regulations, BC Laws is the ideal source. From the home page, choose Laws of British Columbia, then Public Statutes and Regulations. Under the drop-down menu for P, choose Professional Governance Act. You can then choose to read the Act, or navigate to the regulations under the Act. Recognizing that reading the legal text of acts, regulations and bylaws may not provide the guidance someone needs to understand what a reserved practice is, there is other supporting information available to help clarify. There is an OSPG guidance paper that explains the PGA framework for regulated and reserved practice. It is similar to this recording but with more specific detail. Another useful information source is descriptive materials produced by regulatory bodies. Descriptive materials are intended to provide a relatively plain language explanation of what the practice of a profession is, and which aspects of professional practice are reserved only to registered professionals. The regulatory bodies are the best source of information about their professions. They provide extensive information and guidance on professional practice. Examples include standards for specific aspects of professional practice. Another example is joint practice guidance produced by more than one regulatory body respecting activities where more than one type of registered professional has practice rights. Contacting the relevant regulatory body may also be an option to address questions about reserved practice. Regulatory bodies generally prefer to proactively support people and businesses to comply with reserved practice requirements, rather than conducting enforcement activity after the reserved practice has been infringed on. They may be able to answer questions about what is or is not reserved, or refer you to advice or resources to help you understand their reserved practice. In terms of key takeaways from this recording, it is worth emphasizing that reserved titles and reserved practices are intended to mitigate risk to the public and the environment. The main point of restricting advice or services within professions is to ensure that only qualified, competent and accountable professionals undertake activities that pose a safety or environmental risk. In working within their reserved practice, professionals accept responsibility and liability for the advice and services they provide. A second important point to emphasize is that regulatory bodies are legally obligated by the PGA to enforce their reserved practice. Section 22 of the Act requires them to preserve and protect reserved titles or reserved practices as applicable in the public interest, and to guard against the unlawful use of reserved titles or the unlawful practice of reserved practices. Awareness of reserved practice is important for staying in compliance with reserved practice rules. It may not always be obvious or intuitive that an activity is within a profession's reserved practice. For example, a volunteer offering advice or services for no charge could be infringing on a profession's reserved practice. An employer's actions can result in practice infringement if the employer hires someone who is not a registered professional to perform work that is in the reserved practice. There is no exemption for public sector employers. They, their employees and their contractors, need to comply with reserved practice requirements. There are options for staying in compliance with reserved practice rules that recognize that it is not always possible to hire a registered professional for every task. A registered professional may be able to supervise non-registrants, or supervise trainee class registrants who don't yet have reserved practice rights. Technician class registrants may also be able to perform work within a reserved practice. It is not always necessary to hire a professional from the full registration class, depending on the work that needs to be done. There are resources to help with the complex concept of reserved practice. Information on OSPG's website may be helpful for understanding the framework at a high level. The regulatory bodies are the best source of profession-specific information about their practice. Sometimes it may be necessary or appropriate to connect directly to the regulatory bodies for specific questions, especially when it comes to compliance with reserved practice. We appreciate your interest in this recording. Thank you for your time.